Dear all, once again I welcome you all to the final part of the presentation on legal amendments related to victims of crime in India. In this presentation, I will be sharing the information about the victim concerned aspects in the Criminal Law Amendment Act 2018. As like 2013 Criminal Law Amendment Act, in 2018 amendment also the major amendment provisions focus on the sexual offences against women and children. The amendment includes amendment in Indian Penal Code, Indian Evidence Act, Code of Criminal Procedure, and Protection of Children from Sexual Offences Act. I am starting with the newly inserted sections under IPC. Those sections are Section 376, subsection 3, Section 376 AB, Section 376 DA, Section 376 DB. As we know, all these sections are related to rape offences. After subsection 2 of Section 376 IPC, new section, that means subsection 3, was inserted. It says, if a rape victim is under the age of 16 years, the offender shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life. That means the remainder of that person's natural life, and shall also be liable to fine. Section 376 AB talks about punishment to the offender who has raped the victim who has not, or whose age is below 12 years old. In such case, he shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which means person's natural life, and with fine or with death. Thirdly, Section 376 DA says where a victim is under 16 years of age in case of rape by one or more person constituting a group or acting in furtherance of a common intention. That means gang rape. Each of those persons shall be deemed to have committed the offense of rape, and every one of them shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life with fine. Finally, Section 376 DB talks about punishment for gang rape on women under 12 years of age. In such case, each of those persons involved in gang rape shall be deemed to have committed the offense of rape and shall be punished with imprisonment for life, which shall mean the person's natural life and with fine or with death. All these sections have the mandatory provisions for the fine. So here in victimological perspective we can say as it is received from the offender, we can say it as a form of restitution. So the law says the fine shall be reasonable to meet the medical expenses and rehabilitation of the victim. We can see the two major amendments of this act. One is the severe or increased punishment for sexual offenses of children, and another one thing is focusing on restitution. If we take the point number 1, the increased punishment for sexual assault of children, this increased punishment to some extent helps to prevent victimization by giving deterrent effect to the potential offenders, those who are in society. However, as criminologists and victimologists, we know the effect of deterrence is not that much working in prevention, but to some extent it might helpful. The other point, the guilty proved sexual offenders can be isolated from the society for a long time by keeping them in the prison so that others may not get victimized in the hands of these potential and cruel offenders of these heinous crime. In certain time, the punishment is going to be death. In such cases, the offender is going to be entirely isolated from the world. Fine is a form of restitution which helps for medical expenses and rehabilitation of the victim. Though the restitution of the victim or restoration of the victim through monetary support is not possible, because here through this heinous effect victim suffers sociologically, psychologically, especially with post-traumatic stress disorder for a long time. As new sections related to rape offences in IPC were inserted, the necessary amendment in connection through those rape related provisions in Indian Penal Code, Indian Evidence Act, Criminal Procedure Code and POCSO Act have been made. The sections are shown here for your view. I would like to ask you to go through the sections very carefully from the Act. Another thing, in Criminal Procedure Code, a new section 439 1A was inserted after section 439 of CRPC. The newly inserted section CRPC 439 subsection 1A says, when hearing the bail application of the accused of the offences under section 376, 376AB, 376DA and 376 DB of Indian Penal Code. It is mandatory to give, or it is mandatory to ensure the presence of the informant. In many cases may be the victim or any other person authorized by the informant. Under Section 42 of POCSO Act 2012, in the place of 376A, 376C, 376D, it was replaced with 376A, 376AB, 376B, 376C, 376D, 376DA, and 376DB. By this way, all these sections have been incorporated under POCSO Act so that the enhanced punishment shall be given to the offenders of child sexual offenses. As we discuss about victim consent amendments in Indian laws, I would suggest you all to read some of the laws of India, especially the Protection of Women from Domestic Violence Act, POCSO Act, and Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act. While going through these acts, you can see the emphasis given in victim perspective in the recent laws by the Indian criminal justice system. While going through the previously said three laws, one can understand how Indian legislation system meticulously defined the different sort of victimization and approach to solve and protect the victims and prevent the victimization. Firstly, the Protection of Women from Domestic Violence Act 2005, which defines the various forms of domestic violence in a comprehensive manner or in a detailed manner. The Act provides the various roles and duties for the service providers, police officer, protection officers, and magistrate in such a way to help the victim in an optimum level. The Act helps, or the Act provides certain provisions like orders for financial relief to the victim, custody order, residence order, compensation order, according to the need of the victim of domestic violence. Wherever required, service providers shall assist the victim to get medical facilities, safe shelter, assistance, welfare expert, especially family welfare expert, to the extent to find the possible way of avoiding the family problems in future, Also, the act facilitates the victim through the service providers for psychological assistance such as counseling. We all know what is in-camera trial. In-camera trial has been inserted as a provision in the Protection of Women from Domestic Violence Act. The Protection of Children from Sexual Offences Act 2012, briefly POCSO Act, deals with sexual offences against persons below 18 years of age who are actually the children. The Act for the first time defines penetrative sexual assault, sexual harassment. However, in the later amendment, pornography also has been defined. This act is a comprehensive law to provide for the protection of children from the offences of sexual assault, sexual harassment, pornography, while safeguarding the interest of child at every stage of judicial process. The Act incorporates child-friendly mechanisms for reporting, recording of evidence, investigation, speedy trial of offences through appointment of special public prosecutors and designated special courts. The Act also incorporates child-friendly procedures at all stages of dealing with the children. It also provides for stringent punishments which have been graded as per the gravity of offences. The offence is considered graver one if it is committed by a police officer or public servant or any member of the staff at a remand home, protection or observation home, jail or hospital or educational institutions, or by a member of armed or security forces. Thus, the Act shows in the detailed manner how much the criminal justice system in India attempts to help the child victims. As we know, there was an amendment recently in the POCSO Act, the year 2019. As per this amendment, after section 2, subsection 1 and clause D, another class DA under section 2(1) of POCSO Act has been inserted, which define child pornography. According to this provision, child pornography means any visual depiction of sexually explicit conduct involving a child, which include photograph of a child or video or any other form of digital image or computer generated image, not necessary to be original but indistinguishable from an actual child, and image created, adapted or modified but appear to depict a child. This definition tries to avoid ambiguity in understanding the pornography. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act came in the year 2013. This is an act to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of victims of sexual harassment. In the case of preventive aspect, through this act today, all workplaces in our country are mandated by law to provide a safe and secure working environment free from sexual harassment for all women. There are three key obligations imposed on the institutions to meet that standard. One is prohibition of sexual harassment, prevention of sexual harassment at workplace, redressal of sexual harassment to its victims. It is important to note that the Act provides a civil remedy to women victims, and that remedy is in addition to other laws that are currently in force. Apart from that, any woman victim who wishes to report the incidences of sexual harassment at the workplace has the right to take the recourse of either civil or criminal or both proceedings. At this point of juncture, I like to wind up this topic, and once again I instruct you all to go through the relevant materials to these presentations for broader understanding. Thank you.